Welcome, everyone. Today, we're going to talk about when and why a veteran should consider appealing a Board of Veterans' Appeals decision to the U.S. Court of Appeals for Veterans Claims, better known as the CAVC.
Court is a very different experience from what happens inside the VA administrative appeals system. But if you believe the board made a legal mistake or didn't properly consider your evidence, the CAVC may be your only recourse.
First, timing is everything. You have exactly 120 days from the date the board decision was mailed to you to file a notice of appeal with the CAVC. Miss that window and you lose the chance to appeal to the CAVC. You could still have options like filing a supplemental claim, but not to the CAVC.
Also, you can only appeal to the CAVC after the board issues a final decision. In other words, if your case is still being developed or has been remanded, you do have to wait. The CAVC doesn't hear appeals from interim decisions. It only handles final board denials.
There are several situations where you should strongly consider appealing a board decision to the CAVC. The first is legal error. For example, if the board appears to have misapplied the law or ignored a regulation.
And a specific example would be if the board didn't address a theory of entitlement that was either explicitly raised by you or reasonably raised by the record. So let's say a veteran served in Southwest Asia, but the board never considered the PACT Act implications. That might be a legal error worth challenging.
Another reason to consider a CAVC appeal is if VA failed to consider evidence. The board might ignore favorable records or fail to give the veteran the benefit of the doubt as required by 38 U.S.C. section 5107B.
You might also consider a CAVC appeal if VA hasn't fulfilled its duty to assist. For example, if VA failed to collect necessary medical records or didn't provide a required examination, that can be grounds for appeal.
VA might also have made procedural errors. For example, if you didn't get proper notice or if the board mishandled how evidence was used, that's a due process issue.
Now, some caveats about appealing to the CAVC. One thing to remember about court appeals is that VA is now allowed to be adversarial. VA doesn't have a duty to help you anymore, just defend their decision. It's strongly recommended that you find an experienced veterans law attorney who can take your case, find weaknesses in the board's reasoning, and bring in stronger legal arguments.
While a veteran technically doesn't need a lawyer to file, the arguments need to be sharply written, legally sound, and backed by precedent. That's not something most veterans or even most VA advocates have experience doing.
Another thing about court appeals is that the CAVC does not consider new evidence. It can only look at the record as it existed when the board made the decision on appeal.
Also, remember that the court won't usually grant benefits outright. More often, they'll remand the case back to the board to fix their mistakes, or they might affirm the board's decision if no error is found.
So to wrap up, appealing to the CAVC isn't the right step for every case, but when the board gets it wrong, the ability to take them to court is a critical opportunity. And for many veterans, court is the chance to challenge VA before a neutral judge and break the cycle of administrative appeals. With the right representation, a CAVC appeal can make all the difference for your case.
Okay, that's all for today. Don't forget to like and subscribe for more veterans law content. Thanks.